Nancy, I work with a lot of doctors. And if you work with a lot of doctors, you probably know more than one who's been sued at one point or another. And in my experiences, the lawsuits have been frivolous. In other words, the allegations that were made were groundless. But from the physician's standpoint, that's really not relevant because they still have to go through and live through the years-long nightmare of defending themselves. And the risk that they face in the absence of really high-level asset protection planning are enormous because, one of the truths of being an MD or a DO or a DDS or any number of other medical professions that have high incomes is that if something happens, whether you're at fault or not, but you're involved, and the lawyer that represents the person who's making the claim sees that MD/DO and they see dollar signs. And sometimes that's true, that the physician or dentist has a lot of assets, and sometimes not. But irregardless, that's what they see. And so, first level defenses obviously are malpractice insurance, errors and omissions insurance. And, for small claims, that might be enough. But, for those multi-million dollar lawsuits, that everything the physician owns, everything that they plan for can be at risk. Can you talk about how important it is and some of the methods that have to be applied in order to protect a physician's, dentist, other professionals' assets if they fall victim to that lawsuit, whether they're at fault or not?
Certainly. Whenever I consult with a physician or any kind of professional who is exposed to professional liability, I usually counsel, and often there's a couple involved, one of whom bears the professional liability and one not. Now, the counseling can get problematic if both are physicians.
And, we're seeing more and more
we're seeing more of that. But typically, if one is a physician and one is not, we will suggest that the home, for example, be put in the name of the non-physician spouse's name. We will, and frankly, all of the what I call in my world, you probably call non-qualified assets. I call them after-tax assets. Right. If the marriage is stable, and of course that's always
it's a dynamic you can't really count for.
Yes. We suggest that the non-qualified or after-tax assets be put in the name of the spouse who is not exposed to professional liability. We've also we do trusts typically we do trusts for the tax planning aspect of a high net worth person, but the type of trusts we do will not shelter a physician or other high liability professional from that liability when it comes. And so then we may need to consider a limited liability company, incorporating that. I just read a case this morning online, though, that can be a little tricky. If we could even do that for the house, but lending institutions balk at a transfer of real estate to an LLC if it's got a mortgage on it. So then we have to deal with that.
Yeah, they worry about protecting
their
rights to collect on the mortgage.
There are domestic. Ohio has a domestic asset protection trust statute for high liability, high net worth people. Yeah, there is a waiting period for transferring assets to that, though. You just can't. You can't get the complaint in the mail. Oh my gosh, I'm getting sued, and then go to your lawyer and do that trust to transfer assets, because there is a waiting period for that.
Right.
And then certainly,
in other words, you can't do any ex post facto planning in that regard, asset transfer.
Right. I recommend to all of my clients, I mean, my low income clients and my high net worth clients, that they should have as much umbrella liability insurance as they can afford to get, and certainly equivalent to the assets that they are protecting. That's not a document that I would write. but that's just an important financial aspect of asset protection planning
Right.
that needs to be done.
Yeah, and I couldn't agree more. I talk to all of my young clients and tell them, look, you got renter's insurance, you got car insurance, you got homeowner's insurance. You can get an umbrella rider on that policy for $1 million or $2 million for a couple $100 a
Right.
year.
It's very inexpensive. Very.
And it is just and here's something we know too is that if a person doesn't have a lot of financial assets and they make a mistake, and the lawyer that's suing them sees a sizable amount of coverage for under a umbrella liability or auto liability or homeowners, that is really the hurdle they choose not to even try to get over. The attorney will likely settle for what the insurance will pay, and you protect your own personal assets that way. And really, in a lot of the asset protection planning trusts, where assets are transferred and you use and I don't understand these things, but things like charging orders and all of those kind of things, that is a really high level and sophisticated kind of planning. What you're really doing is you're just trying to create higher and higher hurdles and barriers for the attacking attorney, so to speak, to get over. Right. And when eventually they're going to turn to their client and say, we need to settle this, or you just take it all the way and you get your judgment in court, but you are still able to protect your assets that way. Is that right? I mean, is that the way it works for the most part?
Well, I don't litigate, so I cannot fairly
you can't
comment.
Speak for the other side.
I really can't. I'm a transactional lawyer. I write the documents, and I try to be aware of the types of planning, asset protection planning, that need to be done. But the process on the other side, I don't know. Okay. But I did want to mention one other thing, and that is certainly in the marriage context or remarriage context, the premarital agreement as well is certainly an asset protection vehicle that we use, and the funded revocable living trust as well. And the funded revocable trust can be kind of a substitute for a prenup, as we call it, if the beloved won't agree to sign a prenup. And, that happens.
Sure does.
And it happens. And so we'll say, well, then, because Ohio has these things called statutory marital rights that apply at death.
Right.
And we'll say, well, then let's set up a funded revocable trust for you and put as many of your after-tax assets in it as you can. And that will protect you upon death, your estate, from the statutory marital rights that would apply to your new spouse. So that's a form of asset protection planning too.
Okay. Thank you very much.
You're welcome.